this morning's webinar. And so the recording as well as the PowerPoint will be posted on the website. If you have questions, you can use the questions panel on your screen to type your question. Now, we're going to be going through a lot of bills this morning, so to make it easier on me to track the questions, if you can actually include the bill number that you're asking about in your question, that'll make it a lot easier for me. Normally, we do questions at the very end, but this morning we're going to do it a little differently. We've got the presentation divided into 3 parts. We're going to do first the bills that relate to education, and then we'll do Q&A after that set of bills. Then we'll do into a second set of bills, which are more general foster care information, and we'll do a second set of Q&A. And then we're going to end the presentation this morning with discussion about 2-year bills. So these are bills that were introduced in 2015, but didn't make it all the way through the process and are going to be in play next year. And we'll have Q&A after that as well. Normally, we like to try to keep our webinars to an hour. I think with this one, because we have so many bills to cover, we probably will go a little bit longer. So for those of you who can stay on for that last section of 2-year bills and Q&A, just note that that probably will be a little bit afternoon, but we do expect to be wrapping up by about 12:15. The final thing I want to say is actually 2 final things. One is there's a link there to where you can get detailed information about the laws. So because we have so many to cover, we are just going to be giving a very big picture overview of each one of these bills. But if you want to get into the nitty-gritty details, there's a lot of information on that website. Last thing is we are going to be sending out a Survey Monkey after the webinar, and if you can take just a couple of minutes to give us some feedback, that would be greatly appreciated. Next slide. So today's panel is up there on your screen. I'm not going to read through everybody's name because you can see that we have the superstar panel this morning. Basically, like all the advocacy organizations that have been working on these bills are represented. I am so thrilled to have all of these panelists on today. It's wonderful to have so many different organizations represented to talk about the fabulous work everybody has been doing. So again, I'm not going to read through everybody's name. You can take a quick look. They'll all introduce themselves as they come on to do their particular slides. Next slide. So before we jump into the actual bills, I'm going to do a super quick budget recap. So the budget, as folks may recall, actually passed last June. But just as a reminder, we had some great victories during the budget cycle. In child welfare, there was an increase to the foster family agency social worker rate, a dependency attorney caseload reduction so that attorneys can actually have some time to spend with the young people on their caseloads. Foster youth services alignment with LCFS, so we're going to be talking about that more with a bill specifically related to that, but there's $10 million extra for the foster youth services program, $4.2 million rate augmentation for FFAs, foster family agencies, and additional money for counties for foster parent and relative recruitment. In addition, there was some great victories in the higher education world. So SB 1023, which is the bill that passed last year to create targeted foster youth support at community colleges, up to $15 million to implement that. That's in process right now. Some additional money for Cal Grant B Access Awards for community college students. Additional funding for the EOPS program, which a lot of foster youth take advantage of at the community college level. And then $85 million for equity funds, and foster youth are one of the populations that is going to benefit from some fraction of that money. Next slide. So we're going to jump in. We're going to start with our education-related bills. And with that, I'm going to turn it over first to Molly Dunn.
Hello, everybody. I'm Molly Dunn with the Alliance for Children's Rights, and I am thrilled to report that Assembly Bill 379 was signed by the governor on Sunday and will become law effective January 1. And what AB 379 does is it takes that existing set of education rights that apply to foster and homeless youth, such as the right to immediate enrollment, the right to remain in school of origin, to be enrolled in a local comprehensive school, to receive partial credits. The AB 167-216 graduation requirements, and access to the same academic resources, services, and extracurriculars, takes these rights that foster youth and homeless youth already have had for many years and makes them enforceable through the state's uniform complaint procedure process. Previously, there was no way to enforce these rights, and with the passage of AB 379, they will be enforceable by accessing the UCP. There are a couple of factors in implementation, mainly getting the word out. It will be included in the annual UCP notice, and we'll be undertaking other efforts at the Alliance to get the word out on it. And the other thing I should note is that it's looking like the Uniform Complaint Procedure is going to be overhauled this year, and my understanding is that the CDE plans to bring a bill to do that overhaul, and there's a work group that's going to be getting started very shortly to talk about what needs to be changed. And with that, I will turn it over to Martha Matthews.
Hi, this is Martha Matthews at the Children's Rights Project at Public Counsel. The next two bills are basically a way to try and reconcile the some inconsistencies in the education rights of foster youth and homeless youth. Similar education protections were enacted for both of those disadvantaged groups of students at different times, and so there's some sort of funny little inconsistencies in them. So AB 224 fixes a problem where there was a right to have notices posted publicly about the education rights of homeless students, but there was no similar notice posting requirements for the education rights of foster youth. So what the bill does is it requires CDE to develop a standardized notice of the education rights of both homeless and foster students and make it available to districts. Obviously, notices are only as good as the way they're written, and so we hope that there will be an opportunity for input from stakeholders to the CDE in what those notices should actually look like, and maybe an opportunity to improve on existing McKinney-Vento notices, which are okay, but not necessarily in the most clear and accessible language. The next bill, SB 445, similarly, there were some small inconsistencies in the school of origin rights of homeless students versus foster youth. And so what this bill does is it makes the school of origin rights of homeless students exactly equal to those of foster students. And as foster students in K through 8, if their dependency case closes, they can still continue to attend their school of origin through the end of the academic year. Now under SB 445 for homeless students, if their period of homelessness or their homeless status ends in the middle of the school year, K through 8 students can continue to attend their school of origin through the end of that academic year. Likewise for high school students, foster youth, even if their dependency case closes, they have school of origin rights through graduation. SB 445 makes the school of origin rights of homeless students exactly equal to that. So even if the period of homelessness ends, the student can continue to attend their school of origin through high school graduation. And then finally, again, there was just an omission in the law that the definition of local education agency for purposes of school of origin rights did not explicitly include charter schools. Now it does. So in terms of implementation of these two bills, it's important to sort of for stakeholders to kind of get the word out that now homeless students and foster students have exactly the same school of origin rights, and they are more extensive than some people understand. They don't go away when the case closes or the period of homelessness ends. And then likewise, there's a lot of work to be done in terms of working with charter school associations to ensure that they understand and implement school of origin rights and the other rights of homeless and foster students. And with that, I will turn the webinar over to Michelle from the National Center for Youth Law to discuss the next bill.
Hi everyone, this is Melissa San Miguel with the National Center for Youth Law, and I'll be discussing 854. It was signed by the governor on Sunday and went into effect that very day. What 854 does is aligns the state's foster youth services program with the local control funding formula and releases the state's budget allocation for FYS of $25.4 million. Before 854, foster youth services had a more limited definition of who was considered a foster youth than the definition of foster youth found in LCFF. This bill aligns the definition of youth eligible for the program to that of all of foster youth in LCFF. As a result, an additional 40,000 youth, largely those who are living with relatives or in other family settings, will be eligible for the coordinated education services and supports of this program. The FYS program activities have also been updated by 854 to reflect the broader LCFF landscape in education. FYS runs out of the County Office of Education and will now focus on coordinating and collaborating with local agencies such as probation, child welfare, the courts, and for the first time ever, post-secondary institutions. The aim of the FYS program is to minimize school placement changes and support the educational success of foster youth. So we have in statute now is that FYS can coordinate with community colleges, CSU, and the UC to ensure foster youth students meet admission requirements and access programs that will help them matriculate to these institutions. Of note, the SPI must issue a report on the foster youth services program with the next one due in July of 2016. This report will now include a new data point, which is the number of foster youth served through the FYS programs who successfully transitioned to post-secondary education. The State Department of Education will now collaborate with the community colleges and the CSU on identifying indicators to track access to post-secondary education for the youth that are served through the program. And now we'll switch it over to Shihiro, who will discuss SB 252.
Hi there, Shahira here with the California Homeless Youth Project. And I'm talking about SB 252 by Senator Leno, also signed into law taking effect January 1st. So this bill is sort of born out of the recognition that education is a pathway out of poverty for homeless youth. And many homeless youth feel that way, but they face significant barriers to graduating high school. So proficiency exams like the GED or the California High School Proficiency Exam are a really actionable pathway to graduation. However, fees in order to take these exams have nearly tripled in the last 15 years, and really at the expense of some of the most low-income, vulnerable students. So what this bill did was prohibit testing centers from charging the fee to take the GED or the CHISB, which really removes a significant financial hurdle for homeless youth who want to graduate. So some of the factors in implementation for this one. So homeless youth is defined in this bill as anyone under the age of 25 who lacks a fixed, regular, and adequate nighttime residence, the same definition used throughout K through 12, the McKinney-Vento education definition. So right now the Department of Ed will need to determine a procedure for processing the eligibility. There is, the bill does outline who can verify homelessness status, so it can be homeless youth providers, education liaisons, attorneys, etc. But what will that process be, and will that potentially delay implementation? I know that I'll be hopefully actively involved in that effort, and love to be in touch with anybody else who would like to be. Next slide, please. All right, so AB 1228, on-campus housing for homeless and foster youth. You know, in some of the bills that we heard from earlier, it was about making sure that there was more parity for homeless and foster youth around education, because they face so many of the same challenges and barriers to education. And so similarly with this bill, on the higher ed level, it extended some parity for homeless youth as far as on-campus housing goes, by establishing priority for on-campus housing at community colleges that offer it, CSUs and UC campuses. That's something that was already available for foster youth and extends it to homeless youth as well. And requires CSUs and UCs to develop plans that make on-campus housing accessible for homeless and foster youth during breaks. You know, we know that for a lot of young people who live on campus, they're much more likely to be successful in college, but if they don't have a place to live during academic breaks, they might be forced back into situations that are unsafe, or on the streets, or living in cars, which we know a lot of college students are increasingly doing. So to get back to this, it requires the CSUs and UCs that have housing open during breaks to make that housing, first of all, available to homeless and foster youth that are going to be most likely to be in high need of that housing at no extra cost to them, and then also expands the use of admissions by exemption for homeless youth. So I think the primary factor in implementation for this bill is that colleges will need assistance with implementing a plan for on-campus housing during breaks. They'll be need to think creatively and also from a lot of different stakeholders. So again, would love to be involved in that effort, and please get in touch if you would. And I'm going to turn it over to Debbie.
Great, thank you so much. We're going to do a quick round of Q&A right now to just hit the questions that have come in about the 6 bills that we just talked about. So the first one is about AB 379, so this is from Molly. And the question is, does AB 379 include homeless youth?
Yes, it does. Where homeless youth have the same rights as foster youth, they are included in the sections of the code that make those rights enforceable through the UCP.
Great. So the next question is from Martha, and this is about 224. And the question is if there's any specific requirement about where these standardized notices have to be posted.
I don't think so. The bill only what the bill does is it adds foster youth rights to the existing language on posting notices. And so the bill didn't change the what districts are supposed to do in terms of where they put the notices. What I don't know is whether there are regulations implementing the existing McKinney-Vento Act notices that would now obviously apply to foster youth rights as well. If I can research that and get back to the person who asked the question.
Great. Another question for you, Martha, on 445. Can homeless students follow their 8th grade graduation cohort into their school of origin high school?
If they are still in a period of homelessness, yes. They would have the right to matriculate from elementary to middle and from middle to high school according to the feeder patterns of their school of origin. However, if a period of homelessness ends during, say, their 5th grade or 8th grade year, that is during the year before they would move on to another school, then they would only have the right to remain in the school of origin until the end of that academic year. And the same thing is true for foster youth.
So Shahira, there's a few questions about 1228. So first is, are foster youth and homeless students provided any funds to stay on campus? How do they pay for housing?
That's a good question, not addressed in this legislation. So I'm not sure, Debbie, do you know about any, via the FAFSA, is there housing assistance available?
Yeah, and I think the answer is that this bill doesn't provide for funding to pay for housing. The students would have to use financial aid and sort of other regular sources, but that may be a bill for a future year. Another question about 1228, does it apply to summer sessions and summer breaks, or when it's talking about academic breaks, is that just, does that not include summer?
It does apply year-round to all academic breaks, including summer.
So I know that a lot of campuses have a summer session. If a student is not enrolled over summer session, do they still get to stay in the housing free of charge, or is it just sort of for that period between the end of spring and the start of summer session?
I'm not too sure about that, but I would be happy to look into it, and I might be able to answer it before the webinar is over.
Okay, great. Couple other questions. So another question on 252 for you, Shahira. When does this go into effect? Is this sort of the regular January 1st effective date?
Yes.
And then can youth have been previously homeless to qualify for the test waiver, or is it just currently homeless?
They can be previously homeless, so I know that their education liaison at school through McKinney-Vento can verify their homelessness status, and I believe that can, you know what, I'm so sorry. I would love to look into it and see exactly for how long. I know that comes up later in another one of the education-related bills for homeless youth that I'll be talking about in a moment.
Question on SB 445. So Martha, this is one for you. Question is, does this change anything related to transportation? Can schools still stop transporting after students become housed?
No, the bill does not change transportation requirements. It just changes it changes the period during which school of origin rights exist. So during the period that those school of origin rights exist, I believe that transportation rights would apply. So for example, if someone became housed in the middle of their 8th grade year, their school of origin rights would continue to the end of that academic year, and so would any accompanying right to transportation.
Great. Another question, well, you know what, here's what I'm going to do. We're going to move on to the next section of the webinar. And we've got a lot of great questions coming in, and the panelists are going to stay on the call. So we'll try to get to as many as we can at the very end, but I want to make sure we have an opportunity to cover all the bills. So if we can go to the next slide, I'm going to turn it over to Christina, who's going to jump into some of the legislation specific to the foster care system.
This is Martha. I apologize for interrupting. I just realized that I actually misspoke in my answer to that last question. The bill explicitly provides that the federal McKinney-Vento transportation rules still apply. So the bill does not change existing transportation requirements. So that means that even though the bill extends school of origin rights, it does not extend transportation rights beyond the baseline that already existed under McKinney-Vento. I apologize, I didn't say that exactly right. And now I will advance the slide the way I'm supposed to.
All right, Christina.
Thanks. This is Christina Reel from the Children's Advocacy Institute, and I'm going to talk about AB 217, which is a simple bill that amends Welfare and Institutions Code Section 349. It's a bill aimed to empower youth that are part of the dependency court system. The bill requires courts to actually inform the child of their right to address the court with their concerns and to otherwise participate in the dependency court hearings. And this is so that the child feels more centrally included in the decision-making process. Like I said, it's a simple bill. What we do need to do is work on assuring that all the courtrooms are informed of this change, and it's really a part of a movement to make courtrooms a more inviting place for the children that we serve. And with that, I will turn it over to Susanna.
This is Susanna Niffen with Children Now. One exciting bill I'm presenting on is SB 504. It has to do with the sealing of juvenile court records. For a long time, the cost of sealing juvenile court records was prohibitive for young people. So there was a fee for up to $150, and the youth was required to pay fines, fees, and restitution in order to get their juvenile court records sealed. For many young people, this was just impossible to do. And so the new bill actually says that people under 26 may not be required to pay the fees for sealing juvenile court records. This is really exciting. However, as with most things with the courts, one factor to consider in implementation is making sure that courts and young people actually know that this new right exists. Next slide. AB 592 has to do with foster youth verification. This bill was co-sponsored with the John Burton Foundation to address a very specific issue of foster youth who are older being able to verify their time in care. So many of the programs that we've all fought really hard for and been excited about providing to these young people after their time in care have been very hard for them to actually access, because some of them have a real struggle to prove that they were in care and to verify the dates they were in care. There's currently different processes through the counties, but for kids who move counties or who aren't sophisticated enough to get to the right person at the county level, this has been a challenge. What the new bill says is that if there are problems or if a young person needs to verify, they can go straight to the state. What we've heard from DSS, and this is a factor in implementation, is that what they'll be doing is having young people simply call the state ombudsman office, and that the ombudsman will be able to verify their time in care. The system for doing that is still a little bit in flux. However, AB 592 was passed with urgency, which means it's in effect now, and young people don't have to wait until January. This is a current right. And now
so this is Debbie chiming in. So somebody asked a question about effective dates. So generally speaking, effective dates for bills are January 1st. And if somebody's got an urgency clause, it goes into effect sooner. So folks can state whether your bill has an urgency clause. And if it doesn't, then you can assume it goes into effect January 1st. And now turn it over to Vanessa.
Hello, my name is Vanessa Hernandez. I'm with the California Youth Connection. Today I'm going to talk about AB 260, which supports pregnant and parenting foster youth. AB 260 supports these pregnant and parenting foster youth in two ways. First of all, it'll prohibit the use of past and irrelevant information contained in a foster youth case file as the sole evidence in dependency petitions. This information may include placement history, behaviors, mental health diagnoses, etc. This bill will also require that preventative services are provided to the parenting youth no matter their placement, thus breaking the cycle for foster care for parenting youth. I'll now turn it to Maria.
Thanks, Vanessa. I'm going to talk a little bit about AB 703, which is a juvenile defender training bill. It sets for the first time statewide standards for training and experience for attorneys who are representing youth in delinquency proceedings. The statute requires the Judicial Council to develop court rules for representation, but the statute does specifically set forth a couple of things that are very important. One is that it clarifies that the duty of a defender is to represent the youth's expressed interests as opposed to the youth's best interests. They're supposed to follow what the client expresses that they want. The second is that it requires that defenders maintain the confidentiality of their clients, so that their duty is to represent the expressed interest of their client, as well as to maintain confidentiality with their clients. So it's not the client's parents, it's not anyone else involved in the case. The youth, it recognizes that the youth is the client. And as I said, the Judicial Council will be developing court rules for representation. They're required to consult with stakeholders, and they will actually establish what the minimum training requirements and experience requirements are for defenders in delinquency proceedings. Next slide. SB 731 adds a new right to the Foster Care Bill of Rights regarding gender identity. It adds the right of youth in foster care to be placed in accordance with their gender identity and not with their gender or sex listed in their child welfare records. In terms of factors in implementation, because this just establishes a right. This will require outreach and consultation with stakeholders, child welfare agencies, foster care providers, to establish really what best practices in terms of respecting the rights of transgender youth in foster care with respect to placement. And now I'm going to turn it over to Sue Abrams.
Good morning. This is Sue Abrams with the Children's Law Center. The first bill I'm going to talk about is AB 879. This bill allows notice by electronic mail in lieu of current notice requirements for most dependency court proceedings. The reasons for the bill: first, current notice requirements, which is generally mail, personal service, or newspaper publication, might not best serve families involved in dependency matters. This new bill will hopefully help increase successful delivery of notice, especially to individuals who might be in unstable housing, such as our non-minor dependents. Also, electronic mail can be more efficient and provide cost savings and is environmentally friendly. There are several implementation issues. First, the county and the court in each county must agree to allow electronic notice for this law to be utilized. The party to be served must provide their written consent through Judicial Council Form EFC-005. There are specific safeguards for minors. There are age requirements and also requirements that the child's attorney provide written consent. And this doesn't apply to all hearings in the dependency court proceedings. For hearings that involve possible termination of parental rights, notice must be provided as required under prior law, but may also additionally be provided by electronic mail. And lastly, there's a sunset provision in 2019, so if there's no bill extending this, then this law will not be in effect after 2019. Next slide. The next bill I'm going to talk about is AB 889. Current law right now protects the confidentiality of juvenile case information, requires that juvenile case information only be released after the court is petitioned and the court agrees to allow the information to be released, and that current law providing guidance for that is Welfare and Institutions Code Section 827. This bill clarifies that existing law to specify that federal officials must also file a petition and obtain a court order in order to access confidential juvenile information. The law also defines juvenile information to include the case file and other information related to the minor, including but not limiting to the minor's name, date or place of birth, and the immigration status. Next slide. The last bill I'm going to present is SB 68. And this bill relates to minor parents, so all minor parents, and then non-minor dependent parents, so those youth 18 to 21 who have their cases still open in the dependency court and meet the definition of a non-minor dependent and are parenting. And what the bill does is it does two things. It allows the court at the 18-month review hearing during family reunification to offer an additional 6 months of family reunification, so up to 24 months for a parent who was either a minor or non-minor dependent at the time of the first hearing in the case. And then the bill also requires at each review hearing during family reunification for the court to take into account particular barriers to a minor parent or a non-minor dependent parent when deciding whether or not to return that child home. And now I'm going to turn it over to Anna Johnson.
Good morning, everyone. This is Anna Johnson from the National Center for Youth Law. I'm going to talk about 4 bills total today that attempt to comprehensively address the concern that foster children are over-medicated with psychotropic drugs, so drugs for ADHD or antipsychotic drugs, antidepressant drugs, are typically seen to be overused without medical necessity or without other therapies tried. Our first bill, 238, focuses on providing training about the medications and alternatives to the medications. It seeks to sort of update the forms to the court so that the court who make the decisions have improved regular information It also gets data down to the county level so that they can oversee the practice locally and see where quality improvement might be needed. And finally, the individuals who will be trained underneath the passage of this bill will include a wide range of stakeholders, group home administrators, foster parents, relative, non-relative caregivers, judges, children's counsel, child welfare workers, and public health nurses. So where there was sort of a dearth of information, we'll now have reliable information based on the science for children. Next slide. SB 319 was developed realizing that only about 11% of foster children who are put on a psychotropic medication ever receive monitoring appointments or follow-up based on their treatment plans. So what this does, it authorizes for public health nurses to be able to access the medical records of foster children directly from the providers and prescribers in their health network. Before they sort of had to wait for a social worker or someone else to retrieve the information. So what this means is that we'll have more accurate medical records for foster children, information sooner, and a little bit more collaboration between public health nurses and their social workers or care providers. So there's still a county opt-in for using public health nurses to oversee the actual treatments, and there's a federal match of funds of 75% of the cost of a public health nurse that still remains. We haven't changed anything about that. Next slide. SB 484 addresses specifically oversight in group homes. 56% of children, foster children living in group homes, are receiving a psychotropic drugs, often without adequate oversight, monitoring, or other services provided. What this bill does, it establishes a way to look at the group homes that have high levels of psychotropic drug use without other services provided. We'll call for inspection of a certain number of facilities at least once a year. And where warranted, there will be sort of a review and a plan of correction if any issues are found in those homes that were identified. So thank you, and I'll talk again later on SB 253. And now I'm going to hand it over to Teresa.
Good morning, this is Teresa Thurman, and I'm with the California Department of Social Services, and I wanted to say that I am with the Continuum of Care Reform branch, a new branch here at CDSS, and I'm in charge of stakeholder collaboration, communication, outreach, and training. So at the beginning of this short presentation, I want to give you our email box if you have any questions, and then I'll repeat it at the end. The email box is very simple. It is CCR for the Continuum of Care Reform. So that's CCR at DSS for the Department of Social Services .ca.gov. And I wanted to give that because this bill is huge and it is being broken up into various different work groups. And then also we are working on a communication plan to get information out to the local level. And so if you are with the county, you can contact, if you're with Child Protective Services and interested or in participation on work groups, you should contact the CWDA. If you're with probation, naturally you should contact CPOC, Chief Probation Officers of California. And then also, if you're a provider, then you can contact the Alliance. If you're not with the Alliance, just go ahead and write to the email box and we'll try to fit you in somewhere. So what is this bill about? The easiest way to explain it is that in 2017, congregate care will transition over to short-term residential treatment centers. And those treatment centers will be able to approve resource families to provide care for the children that are in foster care. So it increases the use of home-based care and reduces the number of foster children that are in congregate care. So what does this mean? That means that as a state, we need to increase our foster homes. And so just last week, there was a release of an ACL that will provide funding to the counties for the recruitment and retention and support of foster parents. And so the counties will have the ability to submit plans and how they will be able to do that and ask for funding to support in that area. So it'll also create faster paths to permanency, and more importantly, it'll shorten the time that you spend in group homes, something that we have been working on since residential-based services. So you've seen a lot of bills where it's been piloting, and so now it is here. So again, the department's email box for the continuum of care reform is at ccr@dss.ca.gov. So go on to the next bill. Go back to the previous one. Here's some other things that AB 403 is doing. And you see the first bullet right there where it says eliminate group homes. I would not specifically say that it's going to eliminate, because we at the department recognize that there's going to be occasions where youth are still going to need group homes. So the STRTCs, as I mentioned, will be a new type of group home. And so in the past, youth have had to move from group home to group home in order to receive higher level services. What you're going to see is that we're working on the services coming to the youth no matter where they live. So that's a new structure that we're building. And then also as a part of AB 403, you'll see a new rate structure as well. So there's various different work groups that are working on all of these things. Some of the things that have already been worked on is there's already a CCR FFA work group. The Foster Care Audits Rates Bureau has been working on rates. Just started a FFA communications work group yesterday. And as I noted about the foster parent recruitment and retention and support, that ACL was released yesterday. Last week. So it's huge, and just go ahead and write me. There's the email box down there at the end. Okay. So the other bill, thank you, Martha, is SB 794. And the easiest way to think about SB 94 is that this has to do with HR 4980, and that is a federal bill that includes a lot of different areas. And so basically what we're doing is codifying it into SB 794 and our California laws. So what does it include? It amends the state laws that provide for the identification, documentation of CSEC, victims of sex trafficking. Has to do with the reporting of the victims of sex trafficking to law enforcement. It will outline the protocols to expeditiously locate children and youth in foster care that run away the youth that go missing, and the youth that are what we call AWOL, absent from care. So appropriate reporting to law enforcement when children or youth receive child welfare services who are or that are at risk of becoming the CSEC victims or the missing youth that are abducted, so that they may be enrolled in the National Crime Information Center database. So that's going to be a big one. Law enforcement will be required to report to the National Crime Information Center database. So all of these youth that are missing will be in that national database. So that's a big thing. Next slide. So some of the other things are included in this bill. Another huge bill is reasonable and prudent parent standard requirements and training, expanding the adoption incentive to include guardianship and reinvestment of potential savings, expanded relative notifications, successor guardianships to maintain federal funding eligibility, the addition of fit and willing relatives as permanent plan options, limits and requirements of another plan, permanent living arrangement or APLA, and an increased inclusion of foster youth 14 years of age and older in case planning and transition planning. For years, that transition planning has started at the age of 16, so now we're looking at the age of 14 in this bill. Okay? So now
Great,
we're going to...
thank you. Yeah, let's move in.
I'm sorry.
We're going to move in. Go ahead, Teresa. Did you have
I'm sorry, Debbie. I was turning it back over to you, my dear. Go ahead.
Great, thank you. So we have a lot of questions coming in. I'm going to try to get to as many of them as I can, and I know that Shahira has to jump off the call at noon, so I'm going to start with the questions on her bills and then move through some of the other ones. As a reminder, if you do have questions, please make sure you include the bill number in your question. So Shahira, I know you got some additional information about the question about AB 1228 and summer breaks. Do you want to go ahead and share what you were able to find out?
Yeah, absolutely. So for AB 1228, it's going to be up to the colleges to determine how to address students not enrolled in summer school in their plan. So basically, that is to be determined. So the plans have not been created yet, so of course it will be one of those devils in the details. So there's an opportunity to talk about how exactly the housing will happen, for whom, and when and where.
Right. And Shahira, are you able to respond to questions about SB 252? I know you weren't the primary sponsor of that.
I will absolutely try my best. Yeah, please go for it.
Okay. Okay, so is SB 252 only for homeless youth that are under the age of 25?
Yes.
Okay, great. Another 252, and this may be an implementation question, not necessarily addressed in the bill, but the question is, does the testing center waive the fee, or is the school responsible for paying the voucher?
The testing center waives the fee, so the school is not responsible for paying the voucher.
Okay, great. I think those were your questions. So I'm going to go back now, and for those of you who can only stay till noon, I understand we're gonna go in probably another 15-20 minutes. For those of you who are interested in staying on, we're going to finish up the questions and then talk about some of the two-year bills at the very end. So some of you are sending in some more general questions that aren't specific to a bill. So because of so many questions and the time limitations, for those of you who are asking about plans for future bills and stuff like that, I'm going to really just focus in on the questions that are specific to the bills that we talked about today. So actually, Shahira, one more question for you is, are community colleges subject to the provisions of AB 1228 if there are a handful of those campuses that have housing?
Yeah, if they provide on-campus housing, then yes, they are.
Great.
Yeah, and I do have a response to the question earlier about SB 252, and they do need to be currently experiencing homelessness.
Great, thank you.
Yes.
So the next question is about 854, so this is from Melissa. The question is, it was mentioned that a report will be due in June of 2016. Is this the year-end report due to CDE?
So the report that is due is the biannual report the State Department of Education has done before for FYS and will continue to do. And they, compile the information from the local county programs and then submit that to the legislature. So there'll be this new additional data point, and it's every 2 years.
Martha, this is sort of a general question that I'm going to throw to you, which is somebody wants to know, for the new provisions related to homeless youth, if a homeless youth is not being provided with what the law is supposed to provide to them, who should they contact for help?
Well, first of all, remember that Molly Dunn discussed a bill allowing the uniform complaint procedure to be used to enforce the rights of homeless and foster youth. Now, youth may need help figuring out how to file a complaint, but anyone working with a homeless youth should be able to say to the administrative office at a school or at a district, I want to file a complaint. And the districts and schools are required to provide them with the complaint forms. Molly might want to say more about this.
Molly, did you have anything to add?
No, I think Martha covered it very well. So it's just keep in mind that the ability to file a complaint only applies to certain of the foster youth education and homeless youth education rights. It's the vast majority of them, but you're going to want to make sure that it's actually covered under the bill and the complaint is appropriate.
And then in general, homeless youth don't have a sort of system of legal representation. Probably the best network is the network of runaway and homeless youth providers. At least in urban areas, they will have links to legal advocacy organizations. Foster youth are represented by lawyers in their dependency cases, and they should at least, if they can't directly do education advocacy, at least know where to refer youth for advocacy on education rights issues.
Great. So Suzanne, I've got a couple of questions on 592. Some of these may be, again, questions that have to get resolved in the implementation, but I'll go ahead and see what you have to say on these questions. First is, will there be any sort of time limit on letters of dependency that comes from CDSS?
I'm sorry.
The question is, will they expire? Somebody gets a letter. Is it something they can then sort of keep and use throughout their college career?
So again, you're correct, Debbie, that a lot of this hasn't been spelled out yet by the department, so we're waiting a little bit for more clarification. However, the current letters from the county don't expire, and they're things that if you can hold on to them and keep with them, they can be used for many years. My assumption would be it would be the same with these.
Great. The next question is, somebody wants to know, is there a number a youth can call yet, or is that something that still needs to be worked out?
At this point, what we've heard from the department is that young people should be calling the foster care ombudsman number, and I can take a moment and find that, or if someone has it offhand, but that's the number you should be looking for, is the foster care ombudsman at the State Department of Social Services.
Great. And then one last question on 592. Does it allow third parties, such as a college financial aid office, to request verification from CDSS, or does it have to come?
At this point, it has to come through the youth. Again, this may be something that gets worked out in implementation, but one thing that has been clear is that they need to make sure that the person asking for the information is entitled to that information. So I would say that unless and until we can figure out some sort of a standard procedure or an MOU or something like that with education departments, which may happen, at this point it would probably be best for the youth to simply do it themselves. But again, we'll continue to work on that.
Great. So I have a couple questions on 319. So this is for Anna. So when it talks about authorizing healthcare providers, question is, does that include school nurses?
This is specifically for public health nurses, so administrative nurses. So it's not for all nurses. It's just for the healthcare program for foster children.
Great. The next question about 319 is, do foster youth have any rights in terms of choosing themselves to take their medication or not?
Could you restate that again?
Do foster youth have any rights in terms of choosing to take medication that's prescribed to them or refusing that medication?
Yes, they do. That's this current law, and you can also request a hearing, and you can turn in an objection form under the current law. We're trying to make that more explicit in a bill that I'll be talking about later, SB 253.
Great. So somebody just sent in the phone number for the Foster Care Ombudsman's line, so I'll share that. It's 877-846-1602. And at this point, this bill did just get passed, so they might not be familiar with the provisions yet. And I know that Children Now is going to be working with CDSS over the next few months to figure out exactly how this is going to be operationalized. But that's the place to start on the verification issue. So the next question, I have another question for Shahira on 1228, which is there a timeline for when the UCs and CSUs should be expected to have a plan regarding making campus housing accessible to for foster and homeless youth?
Not to my knowledge, which is sort of unfortunate. So I think it will be up to largely probably the advocacy community to continue to highlight the need for this issue to have on-campus housing during academic breaks for homeless and foster youth, and to get involved in that effort to kind of hold their feet to the fire and help make sure that happens in a timely way, since it is such an urgent need for so many young people.
Great. So I've got a question on AB 703. So this is Maria. So the question is, who does training for the defenders, and how will clients know whether or not the attorneys were trained or not?
Okay. Right now, defender training is done. It really depends on, whether the defender is with the public defender's office or as private counsel. So local bar associations have training. The Pacific Juvenile Defender Center, which is the major organization training resource information for defenders, does training for defenders. And so it's just varied. There isn't any standard place for it. And it's not clear whether or not there will be a mechanism for youth to find out whether or not their defender meets the training requirements. The Judicial Council is going to have to come up with rules for training and experience for defenders. The effective date isn't until July 1st of 2016. So although the bill goes into effect January 1st of 2016, the actual training requirements won't go into effect until after the Judicial Council establishes the rules. And once they establish the rules, the only mechanism would be to really to go through the local court, which is responsible for appointment of counsel, to determine whether or not an attorney meets those rules. Because again, it's going to be up to it's the responsibility of the attorney to meet the requirements. So public defenders associations will have to make sure that their lawyers are meet the standards, and then private attorneys, if they're appointed by the court, it will be up to the court to determine when they're appointing them whether or not they meet the standards.
Great. So somebody's asking if we can repeat the ombudsman's number, please. Actually, somebody just sent in a different number. So I'm looking at the site itself, and the number that's listed on their website is 877-846-1602. So again, 877-846-1602. You can also just Google California Foster Care Ombudsman, and the number shows up right away. So we still have some additional questions, but I wanted to quickly cover the 2-year bills. So for those of you who didn't get your question answered, if you want to stay on after our 2-year bills, I will try to run through some more of them. But why don't we go ahead and move on to the last section of the webinar. So if we can go to the next slide, and Shahira is going to talk about AB 801. So again, these are bills that have not passed, and so they could change dramatically between now and next year. They could pass, they could not pass, but this is to sort of give you an idea of some of what's going to be on deck for 2016. Shahira?
Yeah. So as Debbie mentioned, the Homeless Youth Success in Higher Education Act, AB 801, is a 2-year bill. It is currently in Senate Appropriations. It got a lot of support in the legislature, and sorry, I should back up and say, the primary goal of this bill is to improve enrollment and success in college by providing priority enrollment for homeless youth, which is something that already exists for foster youth in colleges, and then the designation of a homeless and foster student liaison to inform students about the financial assistance available to them, which is a huge barrier. A lot of homeless youth and also foster youth don't know about the financial assistance available to them. And in other states that are doing this across college campuses, which is about 12 other states, they've had a lot of success in terms of college completion. It also would waive the community college enrollment fees, about $46, and then provide in-state tuition to any homeless student who has experienced homelessness over the last 2 years. So why is this a 2-year bill? Like I mentioned, it's currently in Senate Appropriations. Advocates are hoping to get it out early during next session so it can still take effect in time for the 2016-17 school year. Right now, the governor needs to hear from a diverse group of stakeholders about the importance of this bill. Their office got sort of stuck on a very minor issue related to the definition of formerly homeless youth very late in the game, because this is another bill that would support homeless youth up to age 25. And it's okay if their high school homeless youth liaison verifies their homelessness status. So there may be some time in between then. But recognizing that housing instability is very cyclical for a lot of young people experiencing homelessness, and having to re-verify every year can be a barrier, that sort of caught folks up. So that's it. And I'm so sorry. I'd like to turn it over to the next speaker.
Great. So Lynn is up next.
Yes, good afternoon. This is Lynn Thull from the California Alliance of Child and Family Services. The first bill I'm talking about is AB 1299. The issue that this bill is trying to address is to ensure that the mental health services that the foster children need when they're placed out of county is given to them as quickly as possible. So currently what happens is when a child moves from their county where they're brought into care to another county for situations like they're being adopted or they're in foster care, their physical health insurance and coverage follows them right away. So they can, within 48 hours, access physical health service. However, since California operates on a carve-out for the especially mental health services, their responsibility and provision of mental health services remain with their county of origin. So what this bill is trying to do is ensure that their mental health services follow them in a similar way to their physical health system. So this bill looks at addressing two things. One, having a consistent process for that transfer of especially mental health service responsibility and service, and two, to look at the funding to make sure the funding also follows the child to that county. And this bill was given significant support all the way through. There was no opposition at all. We worked closely with the counties and took many of their amendments into this bill, worked with the departments and the governor's staff. So it was stalled in Senate appropriations. There are a couple of things that came up. It's really not clear to us why, because we were working through these issues, but there are two issues that we know of. The first one is there was a disagreement between the counties and the sponsors about who should have the final decision that there could be an exception to that presumptive transfer, to the automatic moving of the responsibility of mental health service to the county where the child is residing. And according to law, that should be the individual or the entity who has ability to consent to the mental health services for the youth. And so we're working out that final language. The other issue is that at Senate appropriations, it was given a fairly high price tag, which really confused us. So we worked with the consultant in Senate appropriations to explain a few things. But really, this is no new funding. This is funding that's already put in the behavioral health sub-account for the counties who provide the service. And there is language in the bill to have a mechanism where that money would then flow to wherever the child is moving. And we have clarified the language around that. So hopefully we can get it moving again. We have meetings scheduled with the departments and with the governor's staff actually today and next week. So it should be moving as soon as possible. Okay, next slide. Our next bill that we're working on is AB 741, and this is to ensure that the crisis continuum of care is available, the complete continuum of care for all youth across the state. Currently, there are bits and pieces of crisis continuum of care in various counties, but no county has a complete continuum of mental health crisis care. When we looked through the regulations and the state mental health plan, the only thing that was missing in order for a county to develop a complete continuum of care was a licensing category for children's crisis residential programs. So it is, the actual service is in the state mental health plan, but like I said, the licensing category is not for anyone under 18. And so this bill is, what we're attempting to do is not promote that children are placed in institutionalized care like crisis residential centers. We're just trying to plug the last gap that exists in the continuum of care. So this was stalled in Senate Human Services Committee by the consultants, and we are working with that consultant to, what she suggested is that instead of leaving it up to the departments to create regulations in a licensing category after the bill is passed, to do that and write it into the bill. So that it is more friendly to children and it can be done more quickly. And so we are surveying other states to see what their licensing category is and what the regulations around those are, and creating that language, adding it to the bill. So this will also be moving shortly. And I will pass it off to Maria to talk about SB 12.
Thank you. SB 12 is a bill that attempts to extend extended foster care to certain categories of foster youth who end up in the juvenile justice system and don't have a foster care placement order on their 18th birthday. So it could be foster youth who cross over to the juvenile justice system. It could be youth who end up in secure confinement, a commitment to a local camp, ranch, or local placement option. It could be youth who cross over. They cross over to JJ. They could be in a foster care placement in JJ, and then before their 18th birthday, instead of being stepped down and placed with a relative, are just released to a relative. So they end up with not having a placement order on their 18th birthday. So we ran into problems in terms of the cost of the bill. There isn't great data available to define the population, so we got some very high cost estimates for the bill. There was a little pushback on whether or not youth who have involvement with the juvenile justice system should be given extended foster care. And so going forward, we're going to just need to decide strategically what's the best way to proceed in terms of whether we should be trying to limit the population to a smaller population, seeing if we can get better data so that we can get a better cost number, but we'll have to see how things go and whether or not we're going to pick this up or start anew with a new vehicle in 2016. And so I'm going to hand it over to, I'm not sure, to Anna Johnson at the National Center for Youth Law.
Good afternoon, everyone. This is Anna Johnson, and one of our bills got turned into a 2-year bill, 253. And what this bill intends to do, basically, in California, 1 in 4 foster children and 56% of children in group homes are receiving psychotropic drugs without adequate oversight, as I mentioned before. These medications can cause irreversible damage, and many youth experience long-term side effects, including diabetes, heart disease, tremors, weight gain. And in our state, the judges are the individuals that authorize the treatment. And so what we are intending to do with this bill is to improve that decision making for judges, provide protections that, before medications are given. And how we do that here is that juvenile court judges will be given more information in their forms that they're receiving, provide criteria to the judges around how to make that decision and when might you want to have a second opinion. It also calls for judges to see the effects of the medications within a 60-day period. So how is the treatment working? Are they making progress, or are we seeing any side effects where we might want to consider a different path? And a final piece is that it adds foster youth voice with an assent form where the youth will fill out if they are agreeing to take the treatment or not, and that will be weighed in with the judge's decision. So those are the 4 pieces. The factors that we're still working out are some of the new rules of courts and forms and what that means, how the payments for a second opinion will be made, and the resources to do that in counties that may not have child and adolescent psychiatrists or psychiatrists on hand. And how do we transmit records in a timely manner so that providers can see the records of a child before they're asked to prescribe a medication. So there's been a request to sort of lay out some of the things that would typically happen in the rulemaking process before the bill is signed. So that's where we're at with 253. And now I'll turn it over to Susanna.
Susanna Niffen with Children Now, and AB 878, Eggman, was a bill that would have created a child-centered foster care rate. It's a very bold step, but one that we feel is really necessary. Our current rate system doesn't necessarily make a lot of sense. It's based more on where a child is placed and who they're placed with and what the placing agency was, rather than the actual needs of the child themselves and perhaps the caregiver and the family that are taking care of them. What we would like to see is, as CCR moves forward and we're really doing a revamp of our entire system, we think it's important to also look at the rates and resources provided to families. If we want to step kids down into more family homes, we need to make sure that those homes have the support services and also the resources that they need to keep that child stable in a home-like setting. One of the things we think is important is that there is a full assessment of every child when they come into care, and it very various points with in-care, and that there's a rate system that's developed that actually pays the family a rate based on those assessed needs of the child and what is going to be required to provide the care. We continue to move forward next year. Hopefully we can get a little bit more equity in our current rate system. The reason this became a 2-year bill is that the department is doing a lot of work last year on 403. We assume there's going to be more legislation in 2016, and there's just a lot of negotiations about whether or not a new rate system can be a part of those negotiations and kind of move forward in that package, or whether it will need to be a standalone.
Great, thank you very much to everybody. So if we can go to the next slide. We're moving into our final Q&A, and we're past time, so we're just going to wrap this up in a couple of minutes. I do want to say a number of you sent in questions about AB 801, the Priority Post-Secondary Education Success for Homeless Youth. And I just want to say on that you know, because it's a bill that's still in progress, there's not necessarily final answers to questions about bills that haven't yet passed. And I imagine that AB 801 will probably change and morph over 2016. And if those of you who sent in questions have ideas for how you would like to see that bill structured, I would encourage you, you can reach out to me and I can connect you to Shahira, because that is something there's going to be continued conversations over the next year. And so I apologize to those of you for whom I was not able to get to your question. We just had so many questions coming in. If you have a burning question that you didn't get answered, feel free to send me an email. I will be sending an email out to everybody after the webinar with the PowerPoint, and so you can reply to that if you have a question about a bill that we didn't get an opportunity to answer, and I will make sure to track the answer down for you and send it out to you. So again, I want to say a huge thank you to all of our panelists this morning and everybody who sent in great questions. And that concludes this morning's webinar. Thank you very much.